Hello guys, welcome on our channel. On our news today, we are going to look at Otiende Amollo Constitution Lessons to William Ruto. The Constitution of Kenya 2010 is not an English novel you read in high school. Tread carefully, sir.
On the floor of parliament, I pointed out the very things that the court now pointed out, okay? And I even told them that I am not in that regime. But assuming that's what you want to do, please do it legally and lawfully. Please make sure that you cannot go and start taxing Kenyans without a legal legislative basis.
Before we continue, kindly subscribe to our channel, like this video, and hit like button. Thank you so much. Now guys, let's dive in. Rarieda Member of Parliament Dr. Otiende Amollo has advised President William Ruto against using the ceremonial sword on Kenyans, but rather on external threats.
The sword or the constitution, it should actually be both. It should not be either or. The president swears by the constitution internally to defend the constitution and the people of Kenya. He is handed over the sword for external aggression, not to use on Kenyans, but to use on those who want to attack Kenyans. So when the president says that the sword is not for cutting mboga, that's where he starts to miss the point. That sword is to protect us from others, not to be used on any Kenyan. For all Kenyans is the constitution.
Speaking on Citizen TV show, the MP cited recent utterances by the head of state where he, Ruto, declared war on anyone against the success of his regime, warning that his critics would know that his sword is not for chopping mboga. Dr. Amollo faulted the president for the remarks, saying, "Constitutionally, the sword should be used to defend Kenya from external conflicts, and not on the country's citizens." When the president says the sword is not for cutting mboga, that is where he starts to miss the point.
I think it's clear that as a country, we are on a trajectory towards doom. And I thought that it is only some of us from Rarieda or the Lake region that are suffering. But having come to Meru, I see it's a common problem. The way the students are stranded in my constituency because CDF has not been released and bursaries therefore cannot be given is the way students in Buri constituency are suffering. The way head teachers and principals are stranded on account of not receiving capitation money is the way principals in Buri are suffering. The way students are suffering under the junior secondary school because there's no money to construct classrooms and their teachers are still employed as interns is the way they are suffering here. So it is clear that we are on a wrong trajectory. It is clear that a lot of things have to change and only a blind person would deny that. Secondly, it's about the judicial. I think it's unfortunate that we're in a situation where this regime has muzzled parliament. I am a member of parliament, but I can confirm that it has muzzled parliament. The last institution that is standing is the judiciary. There's a clear and present danger to muzzle the judiciary so that it can sing the tune of this regime. That would be unfortunate. I think William Ruto must realize that court orders must be respected. And if he keeps saying that he will defy court orders, then we ourselves will go back to the very order that made him the president, the order of the Supreme Court that declared him the winner, and examine if we were to defy that, where will that take us as a country?
That sword is to protect us from others, not to be used on any Kenyan. For all Kenyans is the Constitution. Before we continue, let's understand who is Otiende Amollo. Otiende Amollo was born on the 1st of February, 1971 in Kisumu County at Maseno. He had his primary education at Maseno Mixed Primary School, after which he joined Miranda Boys High School in 1986. He graduated from Miranda Boys High School in 1989 with a KCSE mean grade of A, plain. He subsequently joined the University of Nairobi to pursue a Bachelor of Laws, LLB, obtaining his first degree in 1995. He also holds a diploma in law from the Kenya School of Law. In 1998, he obtained a certificate in international human rights law from the University of Lund, Sweden. In 2004, Amollo obtained a master's degree in Master of Laws, LLM, from the University of Nairobi, DAD German Academic Exchange Program Scholarship. He also holds an honorary degree from Maseno University. Honorable Otiende Amollo is a reputable researcher. He has widely researched and presented on the areas of constitutional law, theory and practice, the African human rights system, the question of HIV/AIDS and the law. He has ever worked for the Kenyan government as the chairperson of the Commission on Administrative Justice, Office of the Ombudsman. He has had other several responsibilities in the country, such as Chair of the International Commission of Jurists, Kenya section, Chair of the ActionAid International, Kenya, Secretary General of the East Africa Law Society, Council Member of the Law Society of Kenya. After understanding who is Otiende Amollo, let's continue with our story today. According to the advocate, President Ruto has been ill-advised and should rescind his sentiments and instead use the sword, which is a reflection of authority, to defend the country.
That's number one. Number two, the way you phrased it, that this war between the executive and the judiciary, there is no war. And it reminds me of, I've been watching news a lot. And the international media, especially, I don't know whether I'm allowed to mention,
yes,
but let's say,
yes, you can.
Yes, if you look at CNN, for example, reporting, when it was between Russia and Ukraine, they clearly wrote the Russian war on Ukraine. Mm-hmm. Now that is between Israel and Palestine or the Hamas, it's not Israel war on Hamas. They say the Israel-Palestinian conflict. But if you watch Al Jazeera, on the other hand, they say the Israeli war on Hamas. Mm. In our case, it is not a war between the executive and the judiciary. It is the executive war on the judiciary. The judiciary has not opened any war on the executive. Lastly, and this is where my point of departure from Honorable Sholei, it is okay for governmental agencies, the principal arms of government, we have four, okay, of state. The traditional executive, judiciary, and the legislature. But we also have independent commissions and offices who, it has been argued, can actually stand as independent organs of state. But the point is this: among these bodies, there are some which are meant to check on others, but there are others don't have the power to check on others. Let me explain. For us in the legislature, we have a constitutional mandate to oversight the executive. We oversight the executive by determining the budget. We oversight them by deciding whether the actions of the executive are reasonable or not. That's why even the president addresses us once a year. So we have that mandate under Article 94. The judiciary oversights both us and the executive under Article 165. For us, they determine whether any law we have passed is constitutional or not. Okay, they can't make law, but they determine. Yeah. For the executive, they decide whether any executive action is within the constitution and the law or not. So it's perfectly in order for them. The constitutional commissions and independent offices oversight all of us, the legislature, the judiciary, and the executive. However, the executive is not given any constitutional mandate to oversight either the legislature or the judiciary. The explanation given by Honorable Sholei cannot be faulted on its own, but that's not what's happening, okay? The process of what's happening is a process essentially of witch hunting and trying to cause disaffection, not even against an individual judge, but against the institution of the judiciary. Look, there are mechanisms for checking the judiciary. I can outline like 5 very quickly. First of all, in terms of decision making, if you think a judge has made a mistake, you can apply for review. And there are 2 kinds of review. There's administrative review or judicial review, or you can appeal. That's number 1. Number 2, within the judiciary itself, the Constitution allows you, if you think one judge is likely to make a mistake, you ask for an uneven bench. And in fact, the Constitution itself says that if it's a question that raises substantial issues of law, then it must be at least an uneven bench of 3. So that's internally. Externally, if you think a judge has made a mistake, you go to the Judicial Service Commission. And you can either do it anonymously or you can disclose. So, for example, if the president believes that he has evidence against any individual or some judges, he can do so himself, or he can cause someone else to do it, and he can even do it anonymously. The JSC can act of its own motion and investigate. Secondly, the criminal jurisdiction still remains. The president chairs the National Security Council. That is actually the closest he can come to dealing with the judiciary, because he chairs the National Security Council, of which the National Intelligence Service is part of. And one would expect, therefore, that he could get briefings which you and I might not get. But the question is, if he gets such a briefing, that briefing will not be against the judiciary. It will be against an individual judge and individual actions. So what should he do? Should we go in churches and in funerals and accuse the judiciary in blanket? No. He should do either of two things. Use that information and pass it on to the JSC so that appropriate action can be taken. But if it is corruption, as he's saying, nothing stops the NIS acting with the DCI and the ESCC from dealing with the individual corruption of judges. No judge is insulated from criminal conduct. The insulation is in terms of interfering with their work and removal from office. So if he has all this, why does he keep going to people who don't have that information and can do nothing, yet he knows the right channel? This is not about corruption in the judiciary. This, if you focus there, you are missing the point. Did the president just wake up and think that now there's corruption in the judiciary? No. This is about trying to control the decision-making of the judiciary in view of unpopular and unlawful actions taken by the executive against legal advice. That's the bottom. They didn't know any such thing, because you are right. But let's go back.
No, there's a question. They were in court in Kisumu.
Yeah, there's a question you posed to Madam Shulei,
yes,
about the CJ commenting that the legislature and the executive are joined in the hip.
Correct.
And Madam Shulei didn't answer, but I will answer. The truth is, the answer is yes. Don't look far. Madam Shulei is the deputy speaker. She's the deputy speaker.
Yes.
And she's telling you that it is within our rights to question. When she has uttered the word "we" like 8 times. Is she speaking for the legislature or the executive? The debate is about the executive and the judiciary.
No, political.
You know, Madam Shulei have known for so long.
Political leaders have spoken about.
She's a brilliant lawyer,
yes,
and a very reasonable person. But she has drunk from a poisoned well. And that well is poisoning her mind. So that she has even forgotten that we elected her as the deputy speaker of another independent arm that is supposed to check on the executive. And she is now coming to do what you'd have thought the Attorney General or somebody deep in the executive would be doing, defending executive action and utterances. Now, it is totally wrong. Let me explain. First of all, let me just explain. You know, Madam Shulei says that the executive made certain promises and therefore they must keep them. This is not about who made what promise. And nobody is stopping anyone from making any promise. It is not even the mandate of the judiciary to question the policies and promises made by this regime. The only thing the judiciary can do, and that's all they have done, is to ask, is what you are doing constitutional? Is this also being done constitutionally? The very things that now is making them lament, which is the health laws, amendments, the affordable housing thing, Madam Shulei knows. On the floor of Parliament, I pointed out the very things that the court now pointed out, okay? And I even told them that I am not in that regime. But assuming that's what you want to do, please do it legally and lawfully. Please make sure that you cannot go and start taxing Kenyans without a legal legislative basis. Because the Finance Bill and Act is not a basis. That is just designates the process. There must be a legislative basis. That is what the court told them. That is what now they're trying to do. They could have done it then. So it's not about determining for them which policies. Look, we've heard from this same regime that they will only give employment to those who voted for them. Well, that might as well be their policy because no one has denied it. Do you think that policy can stand the test of legality in court?
Of course, the court will say no. The court will say the Constitution abhors discrimination of any sort, including on political grounds. So such a policy will again be struck down. So instead of looking at where the problem is, which is this, we have a regime that believes that it can impose its will on Kenyans and cannot be questioned in terms of reasonableness, cannot be questioned in terms of constitutionality, and anybody who dares do that then is against the people. That is just wrong. The executive must understand that they have no superior authority over the other arms. Under Article 1, only the people are sovereign. And in fact, if you look at the hierarchy, it is Parliament that is mentioned first, then the executive, then the judiciary. There is no way and no basis on which the executive can believe that it can now impose its will on the judiciary or the legislature. The fact that they've succeeded in doing it for the legislature is courtesy of the leadership we have in the legislature. But I'm glad that the leadership in the judiciary is resisting that takeover. And I think and I applaud you. Now, coming back to whether you should correct, you should talk to your editors.
Yes.
This is splitting hairs. I am not aware of what happened in Kisumu today, but it's very simple. Where the court says that Parliament cannot undertake public participation, because that's usually the word. Public participation comes in many forms. It comes by way of written memoranda, it comes by way of oral hearings, it comes in many forms. Some even just send emails. It's public participation, and all of it is always in a report. Where the court has said that public participation should not be held, and then you say the court only talked of receiving written memoranda, not hearing.
The judgment
it is outrageous. And if that happened, Jeff, then they are succeeding in intimidating the judiciary, which is their entire intention. No interpretation can say that you can now go and be heard, but you cannot submit something in writing, even if you have summarized it in writing. That's just, of course, I don't agree.
You don't agree that has stopped?
No. The question should not be whether there's merit in saying the judiciary is stopping some of his project. Of course, the judiciary is stopping some of his project. The question should be whether they have been stopped legally and legitimately. And the answer is yes. The bottom line is not that question. You see, even today, the president could make it his project to sell the whole of Nyanza province to Saudi Arabia. It can be his project. If we went to court and the court stopped that, will they complain that the court is stopping the president's project? The question is the legality and constitutionality of that action. And if you rephrase that question, therefore, the issue should be this. Is it true that the courts have been unfairly making decisions to the detriment of this regime? The answer is no. In fact, if we were to examine it, Jeff, look at the last 5 years. The decisions that the courts have made are decisions that are beneficial to William Ruto and this regime. Even before he was elected president, Uhuru Kenyatta and Raila Odinga had that BBI project. And I'm the first to agree that it had constitutional issues. I even raised them in Parliament. Again, it was not listened to at that time. The court stopped it to the benefit of William Ruto. Did he complain that the courts were corrupt? No. When we came to elections, and we went to the Supreme Court, and we wanted the Supreme Court to do certain things, including open the servers and all, and they didn't. They made a decision in favor of William Ruto to a great detriment, using actually unpalatable and unjudicious language.
Like hot air.
Yes, like wild goose chase and other things that judges don't usually say. Did he complain that the Supreme Court was corrupt? He didn't.
No.
For the last 1 year, I want you to, and if we had time, I would give you the full list. Look at the list of people who are within William Ruto's regime, either from the deputy president to ministers to MPs who've crossed over to his side to people appointed to cabinet, who had criminal cases, all of which have been terminated. Those who had monies frozen have been given back to them. Did he complain that the judiciary was corrupt? No. Indeed, William Ruto himself even has a case of Weston that has been in the courts for the last 5 years, has not been heard, at the request of his advocate, to stall it. hoping that he would be elected and eventually is elected, your guess is as good as mine where that case will go. Has he ever complained? No. So the question is this, indeed even internationally, if you look at the ICC, if the ICC, which is a judiciary, was corrupt in that sense, who benefited? He was an accused person. Most accused persons are never allowed to stay in their countries as the case is going on. He was allowed to be here, with the result that witnesses disappeared, some were intimidated, the case was terminated. Did he complain? So there's no foundation for complaining, except that now, when the judiciary applies the same laws to stop what has not been done constitutionally and legally, then they now turn and say he's stopping the project. Do you realize that even since we started this debate, Madam Shule has not even alleged that the affordable housing scheme or the health scheme was done constitutionally? She has not, and for good reason, because the soundness of the decisions is difficult to attack. So you leave the decisions and you go to public opinion and say this project is being stopped, this project, without disclosing to them that is the process. It's like BBI. Eventually, you know, even we were dissatisfied. And in the court of public opinion, those who were dissatisfied generally did not care to explain that, you know, the court said that the process was faulty like this. So when you can't explain it legally, you appeal to the emotions, and that's what they're trying to do.
He similarly referred to the ongoing tiff between the judiciary and the executive as a one-sided war.
Now, let me just correct
that. You are, and
yes, I actually agree with you to the extent of saying there's nothing wrong with disagreeing with a judge on a decision. I agree with you completely. But that's not what's happening here. You know, Jeff, in law, there's nothing wrong with criticizing a judgment. You can take a judgment and write an article on why it's wrong, word by word. There's nothing wrong with that. Critiquing a judgment is legitimate and is not contempt. But going to critique the person of the judge, that's a different matter. And that's what they're doing. They're not going for the judgment. They're not taking that decision and analyzing on why it's wrong. They are going for the judges who made the decision. That's the first reason it's wrong. The second reason why it's wrong is this. Even when you critique a judgment, like we did in the Supreme Court, and we did it robustly, you must still accept that that is the decision of the court and you must abide. You do not have the leeway, as William Ruto is saying, of saying that he will not respect decisions that are unpopular in his own opinion. He is becoming more learned than all the judges. You know, it's actually ironical, because the judiciary is to check on the executive and is the head of the executive. But now he wants to arrogate himself the role of checking on the judiciary, like a prisoner wanting to determine for the prison's official how to keep the prisoners from escaping. That's just nonsense. Lastly is this, you know, when it comes to logic, and this is why it's so ironical, and this is why I'm telling you that this regime wants to take us 40 years back. When Madame Shule, who is a brilliant lawyer and knows all this, in fact, she is the one who even started the law reporting docket in this country. So she's aware of all those decisions. She knows that there are cases where you have to go to court and get ex parte orders against anyone. It cannot be that you are telling the court that you cannot issue ex parte orders against the executive. I mean, everyone is equal before the law, whether you are the president, whether you are the executive, whether you are an ordinary person. The same way, the courts issue ex parte orders routinely. For example, if today the EACC think that you have some monies that is stolen, they will not come and serve you. They will go to court and they'll get orders to come and search your premises, your office, to freeze your accounts before they serve you, because if they do, they will not get that money. So they want, and in fact that statement betrays what they want. They want to intimidate the judiciary not to issue any orders against the executive, ex parte or otherwise. That is the bottom line.
That is the
okay, you know very well, as a senior lawyer, he knows this very well. Giving an ex parte order is an extreme measure, because you're giving an order without hearing the other side at all. It's not something to be dished out without too much thought. it's a very dangerous, it's dangerous to do it. So you must really reflect and say, is there going to be, and we know the rule is always that unless you give out an ex parte order when you know that there's going to be irreparable harm and damage, should you not give out that ex parte order. In these cases, what was the irreparable harm and damage? There wasn't any risk.
Of course there was, and I can explain.
What was the risk?
The point is this. First of all, in the eyes of the Constitution, they are just parties to a case. There is no party who's superior because you're in the executive or in the legislature or wherever. You are all equal. So you cannot start saying that you can give ex parte orders against a citizen but not against government. That's just with
that's
respect.
Not what I've said. Ex parte order should be given where there is irreparable harm.
No. I'm coming to that explanation. Your first explanation.
What is the irreparable harm?
I'm coming to that. Your first argument was that they are giving ex parte order as against government. That was the first. Now let's come to the second. That the irreparable. Look at the affordable housing scheme, for example. The bill was passed in Parliament, despite our objections. It became law. It was signed the same day, with the consequence that citizens were being made and are still being made to pay money. They are being taxed without a legal basis. Now look at that. If you are a judge and you are faced with that, where people are being taxed, yes, in a way that is unlawful, and when you find it's unlawful, there is no way of returning that money because they are being taxed in a way that it doesn't come from the pay slip and in a defined manner. Or you delay it so that you determine whether it's constitutional, and if it is, then it will be paid from that day forever. Where does the balance lie? It lies in favor of saying, hold on first. Let's look at the legality before you start taxing Kenyans. As it turned out, there was no legal basis. And their own action actually validates that. To tell you the truth, I don't understand their complaint. Look, the affordable housing scheme, and to disclose, I was the advocate who was leading the team, pro bono. The court says that you did this unconstitutionally because there was no legislative basis. They now say the court was wrong and they have appealed. That's on the one hand. So they believe that decision was wrong. On the other hand, they are agreeing with the decision and they've already drafted legislation which is now going through public participation to enact the very thing and do the very thing the court had advised. So they are trying to probate and reprobate. You can see that they don't even know what they want to do. If they believe the court is so wrong, they have no business passing that law. They should appeal and hope it's overturned. First, I am not sure, and we were discussing with Honorable Shele here, the basis of that statement that the CJ has invited a meeting. Because I read the statement that she read on behalf of JSC. I did not see that. But I admit, perhaps, because I did not watch the actual interview, perhaps she may have made that off the cuff. Now, if she did, and I was asked this yesterday morning, and I was of the firm view that there is no basis for dialogue, and that would be the wrong direction to take, for three reasons. First of all, the Constitution. Article 1 and Article 160 lays a very clear basis of separation of powers, okay? The idea of that separation of powers gives each of these governmental arms a distinct role. And even if we in Parliament, for example, were to disagree with the President, the process is this: we pass legislation. If the President thinks that it's not right, then he returns it to Parliament with comments. If we in Parliament insist that the President is wrong, then with a 2/3 majority, we'll still pass it anyway. For anyone to suggest at that point that what we should do is dialogue is to try to break the walls of separation of powers, to merge the legislature and the executive and the judiciary. The idea in the Constitution is that they must check each other. And when they do check each other, you don't need conversation if they do it properly and constitutionally. Article 160 says the judiciary will not take control or direction from any person. To seek dialogue, to talk to the judiciary about execution of their duties, is to seek to control them and direct them. That's number one. Number two,
but that was
under the Constitution, there's a clear mechanism. if you think that the judiciary is not doing what it ought to do as a body or an individual judge, that's why we have the mechanism of the Judicial Service Commission. And it's not just the Judicial Service Commission. We have other independent commissions that can also act, including the Ombudsman. If you think so, you don't call for dialogue. You invoke that avenue. Quite honestly, if it were to turn out that there are 2, 3, 10, 20 judges who are corrupt and the president knows it, then he is actually acting unconstitutionally. He is not protecting the Constitution. It is in our collective interest to smoke them out through those processes and deal with them. But what they are seeking to do is to say, now we are ready for dialogue with the Chief Justice. The Chief Justice cannot even hold dialogue because the Chief Justice as CJ cannot hold dialogue with the President on the direction the judiciary should take on decisions. It would be the Judicial Service Commission. But even the Judicial Service Commission cannot control individual judges on how to make their decisions. In fact, you'll be surprised, Jeff. Do you know in law, and it's written in the Constitution, a judge is allowed to even make a wrong decision in law, provided they have made it in good faith. Yes, they're allowed. So you can't start holding decisions on how a judge should make a decision. If it's in bad faith, smoke them out. What this would amount to is wanting to be a judge in their own cause. The judiciary is supposed to oversight you, but now you are calling for a meeting where you are chairing to discuss with the judiciary how to oversight you. It's like somebody coming to your house, they want to throw you out, and then they say, now you come, we talk. No, you throw them out first. People can talk, and that's what the judiciary must do. No. Reject this over. You know, President Ruto is trying to make the same mistake Uhuru Muigai Kenyatta made, and I made this comment, when he refused to appoint certain judges on account of having some dossier against them.
Right.
I firmly submitted that the president does not have such discretion. If he has such discretion, once the Judicial Service Commission recommends a judge, first, you should submit it in the process of recommendation, so that they are not recommended. But if you withhold it and then they recommend that judge, then your only leeway is to appoint that judge. Once they're appointed, unleash what you have to the commission, then the judge can still be removed anyway. Now, that is the mistake William Ruto is trying to make here again. There are certain things you cannot fight, like the constitutional provision protecting judges. You must just follow the law as it is. There is nothing to dialogue. If it's corruption, how do you dialogue over corruption? If he says that there are judges who are corrupt, how do you start dialogue with the Chief Justice to tell them that now tell that judge to be less corrupt? No. The president is on record as saying there are corrupt elements in the judiciary. Yes. He has not made any other complaint. Right. The only other one you've made here is that the judges are making decisions, frustrating policies of government. How do you start discussing that? That now tell your judges not to frustrate policies of government?
There is no war between the executive and the judiciary. It is the executive's war on the judiciary, since the judiciary has not opened any war on the executive, the lawmaker said. President Ruto has, in the recent past, threatened to use his sword against corrupt individuals or anyone seeking to derail his administration's agenda. Speaking at a Thanksgiving Mass in Kisii County last month, Ruto expressed his intention to use the symbolic sword to weed out crooks opposing the housing levy, prompting concerns and reactions. We have come to an end of this video. We remind you to please subscribe to our channel if you have not yet. Kindly like this video and leave a comment for us and other viewers. Thank you so much for watching our video up to the end. Let's meet in our next video. Goodbye.